Thank you. May it please the court. Number 22 of the defense motions is prohibiting a witness by the name of Donald Williams from testifying as to his martial arts training and various components, opinions that he's made relevant to the use of force used in this case by the Minneapolis Police Department. Mr. Williams was one of the civilian bystanders who was captured in the widespread Facebook video, who in the course of that video was wearing a Northside Boxing Gym sweatshirt. He has made several statements to investigators detailing his training as a mixed martial arts fighter, wrestler, things of that nature. And he offers opinion as to the move that was used, or the purported move that was used by Mr. Chauvin in this case. So what we are asking the court to do is to limit or exclude his opinion. I do not believe he can be qualified as an expert in this particular case. For the record, I am not suggesting that he cannot testify as to what he observed. Clearly, he was a bystander. He was there. He was present. What he saw, what he experienced, those are all, again, legitimate areas. But what it seems to, based on the discovery, what it seems to be happening is they want to qualify him as an expert in the fields of mixed martial arts, jiu-jitsu, all of that. And that's where I think it runs afoul when we get to that type of testimony. His training, which I'm not disputing that he has or fought or any, I don't know. Number one, we don't really have any foundational records to establish that other than his testimony. Number two, the fighting and training to be a mixed martial arts cage fighter or competitive jiu-jitsu fighter is much different than the training that the Minneapolis Police Department uses. And so ultimately, that type of testimony I think is prejudicial. I think it's irrelevant. It's not, it should not be permitted.
All right. State's response? Mr. Frank.
Good morning, Your Honor. Thank you. Donald Williams, we will be able to lay foundation for exactly what is at issue here. Donald Williams began wrestling at age 13. He wrestled into his college years. Wrestling, of course, is all about leverage and weight and force through body-to-body contact. In about 2009 or 2010, he started training in mixed martial arts. And during that 10 years leading up to this incident, since he was age 21 or 22, was in the gym every day for 8 hours a day training in mixed martial arts. He has boxed or fought 18 to 20 professional fights and has told us that in his training, he has trained with police officers from various police departments when they come to the same gym and do training there. We know that use of force officers will testify that they have also taught jiu-jitsu moves as part of their use of force training, because it is using the application of force and body weight to control other people. We expect Mr. Williams to testify that as part of his training, they are taught chokeholds, and that is a way of controlling another person by rendering them unconscious. And as part of that, he knows how it feels to be rendered unconscious. And they actually practice that in their training. They practice it because, in part, they have to know when it's time to tap out, right? When they know it's gone too far, and if it goes too far, somebody can be seriously injured. Somebody can die. That's all part of his training and his experience in mixed martial arts over many years. They're also taught to know how to control their breathing when they're put into a chokehold so that they are not so that they don't go too far and end up dying as a result of it. The defense will no doubt, as their experts have opined, allege that the bystanders were an unruly mob, and that Mr. Williams was one of the most vocal members of that unruly mob. This unruly mob that consisted of some teenage girls, a 9-year-old, an elderly gentleman who was trying to help, and Mr. Williams, who was quite vocal. Anybody who has seen the bystander video knows who we are talking about. And what's important in large part about Mr. Williams' testimony is he was so vocal because he knew all of this. He knew how serious this situation was. He knew that Chauvin was killing this man.
Who?
Mr. Chauvin was killing this man because Mr. Williams knew from 10 years of training and experience in mixed martial arts alone that this was very dangerous and was most likely cutting off his blood supply and his ability to breathe.
Can I ask you a question? If I recall from the probable cause motions and that, when we had some of the videotapes as part of the record, Mr. Williams, did he use the phrase blood choke or something to that effect, saying something to the officers?
That's correct, Your Honor. And what a blood choke is it, it's different than we think of choking on a piece of food, right? It's affecting blood flow. And Mr. Williams will explain that a blood choke is where you do that. You try to interfere with the blood flow to render that person unconscious. And he recognized aspects of that in what Mr. Chauvin was doing at the scene. He sees that. He's standing feet away and he's seeing it. That's partly why he is so agitated and so vocal at the scene. Not because he's a rolling 30s blood member, he's clearly not, because he's a mixed martial arts person, 10 years experience, who knows how serious this is, and something has to be done. And that's why he's so expressive. He can see in Mr. Chauvin's position that Mr. Chauvin's knee is on the neck. It's perpendicular to the spine in the area between the shoulder blade and the ear, where it could interfere with blood flow to the brain and the rest of the body. And that's why it's so serious. Mr. Williams will also testify to what he calls a shimmy. And it's a move that mixed martial arts athletes are trained to do to tighten that chokehold. And it's a body movement that Mr. Williams will point out for the jurors at trial, where it can be seen that Mr. Chauvin is rocking back and forth to secure that hold, to secure Mr. Floyd to the ground. So his training and experience in everything from wrestling through all his mixed martial arts and boxing is relevant to what he is seeing and what he is explaining and what he is trying to tell Mr. Chauvin and the other officers to do. And that's get off him and get him help because you're killing him. So there is foundation for that testimony through his training and experience. We're not testifying that we're not going to try and qualify him as a medical doctor, but it's relevant and it helps the jury understand, first of all, why Mr. Williams is so upset, and secondly, what he is seeing from mere feet away, live and in person, about what Mr. Chauvin is doing to Mr. Floyd. So that foundation we will be able to lay through his testimony, all of which has been disclosed, and will be offered for those opinions. So we would ask the court to deny this motion.
All right. I think at some point it becomes a medical opinion, and I don't think the state is offering it for that purpose. For example, that it was the hold itself which contributed to the death of Mr. Floyd. It appears to me that this is actually similar to the firefighter, where this person can talk about their training and experience. And specifically, I think in this case, because he does say, and it is audible on the video, that the term's blood choke, I think he is entitled to say what his experience is and to explain what he meant by that, and also the shimmy, to be honest. that that's what he thought he saw, and that he thought it had gone too far because in his training, once a person is unconscious, I assume this is what you're talking about, Mr. Frank, that once he's unconscious, that the hold should be lifted. That's his training. He's not to opine on anything else. He can't go and say this is what caused his death or this is what caused him to go unconscious. All he can do is talk about his observations, and based on his experience, that he thought it was a blood chokehold, that he was seeing a shimmy, to explain what those terms mean according to his experience. And I would even allow him to say, and based on his experience, he thought that the hold was kept on too long. I think beyond that, then we start talking about medical opinions. Did it cause the death? Did it cause him to be unconscious? I think he can talk a lot about his observations and explaining what he thought about the hold itself and how that it went too long. Is that kind of clarified for the state where I'm drawing that line?
It does, Your Honor.
Mr. Nelson?
He does.
All right. Let's move on to the next.